So there's been a number of cases in the state of Illinois when judges have ruled against individuals in important property considerations because they haven't complied with discovery. What does this mean? Let's say that you've been under court order to provide documents to the court, tax records, business records, account statements, and you've refused to do it. In many of these cases, judges have ordered extraordinary property victories to the other side as a sanction for the individual who did not comply with discovery. If there's a deposition, for example, that you've been ordered to attend, which is where you're under oath, swearing that everything that you say is going to be true, and there's a court reporter getting everything down, but you don't want to go, you're scared, or you're just trying to avoid the scrutiny of the courts. Again, there have been a number of cases where the judges have awarded extreme maintenance amounts, formerly known as alimony, or extreme distributions of assets in the favor of the other side as a sanction against the failure to comply with discovery. That's why it's extremely important to make sure that you're working hand in hand with your attorney to ensure you understand what's being asked of you and that you're giving what's required to the court. At the same time, you don't want to necessarily give more than what's being asked and put yourself under too much exposure. It's a very thin line, and it's important, as I say, that you work carefully with your attorney to understand exactly where not to cross the line and where to stand to protect most powerfully your own interests. One of the mistakes that we see regularly in these cases is when a client is not prepared to interact with the guardian ad litem. The guardian ad litem is an extremely important figure in the divorce process. The GAL will often make recommendations to the judge that the judge is going to follow because the judge personally appointed the guardian ad litem in this case. And where the judge appointed the GAL, the judge is going to see the GAL as almost an extension of the judge himself or herself. So the recommendation of the GAL is going to have tremendous weight with the judge with regard to who should receive certain rights in the custody process. Therefore, it is very, very important, both for the GAL and for the client, for you, that you've worked with your attorney to understand what the GAL is going to do, what sort of questions the GAL is likely to ask, what sort of things is the GAL likely to look for, so that you are prepared to present yourself in a way that is both helpful to the GAL, makes their job easier, and makes you ensure that you are giving your best self to the GAL, that you are showing the best you as a parent that you are with your children and that you hope to be in the years to come. One of the worst things that we've seen happen regularly, ways in which individuals essentially shoot themselves in the foot in this process, is to use the divorce process as a way to try and harm, hurt, punish their ex, to get out, as it were, to expiate their own bitterness against their ex for things that might have happened during the marriage, and use the divorce process as some kind of a weapon to punish. This tends to drag out the process for years more than necessary. It tends to bring about tens of thousands of dollars more in attorney's fees that necessarily need to be spent, and it tends to anger judges as well, who often resort to all manner of punishments against the party that they see as unnecessarily dragging out a case. So there's a number of ways that we try and bring these issues before the court if we're on the other side. And if you're on the other side, we're your lawyer, because that's the sort of people that we like to represent. Is we bring these issues before the judge to alert the judge to the fact that the other side is abusing the court process, so we can avail our clients of some of the tools that the court can use to convince the other side that it's not in their best interest to prolong this process for the wrong reasons. Often in these cases, we find that people come back to court and they come back to us years later. Often they've had another attorney in the initial stage of the process and they need to reopen the case because they didn't like the result that they got the first time. And they find that they really rushed to the finish line in the initial case. And now that they're back for a second bite at the apple, it costs often several times more to do it right the second time than it would have cost to get it done right the first time. It's really important to understand that you're going to live with the results of this divorce process for many, many years to come. If there's children involved, it's going to impact your life, not just until your children turn 18, but it's going to affect your relationship with them for the rest of your life. You don't want to be in the nursing home alone, heaven forbid, where you have no relationship with your children. You really should make sure that the result is a proper one you're comfortable with, one you can live with, one that you are going to leave confidently with and feel good about yourself in the process, because, as I say, it's going to affect you and your family for decades into the future, and often is much more expensive to try and come in and reopen and fix at the second bite at the apple. These are some of the time mistakes we see in divorce, and we're here for you for your free consultation whenever convenient for you. Don't hesitate to reach out to your friends, your attorneys at khk Family Law.